Welcome to our latest episode. This week I want to talk about Employment Tribunal fees, which were abolished last month, and what steps employers should be taking as a result. We've certainly seen an increase in inquiries over the last few weeks just in relation to Employment Tribunal fees and what this kind of means for employers. So I thought I'd just kind of share our thoughts on that with you today. Just to give you a bit of background, so Unison, the trade union, have been campaigning for some time to have employment tribunal fees abolished. For those of you that are aware, the government introduced these in 2013, and as a result of employment tribunal fees being brought in, there's been over 70% reduction in employment tribunals being raised. So that's obviously been quite positive for employers, but not so positive for people wishing to kind of make a claim against their employer or their ex-employer. So what that meant was that people had to kind of pay a lodging fee just to kind of bring about an employment tribunal claim, and then if the case then actually made it to an actual hearing, there was a further kind of lodging fee to be paid at that point. So someone to really bring a tribunal claim about would have to have kind of paid over £1,100 just for that case to get to tribunal. So quite a kind of large cost for someone wishing to make a claim, and given that there might be someone who's lost their employment, that is quite a significant cost that they would have to have found. So that's why Unison have been campaigning for some time for that to be abolished. And what then happened at the end of July is that the Supreme Court ruled that that was unlawful. So tribunal fees have been scrapped, and as of the end of July, the government have kind of abolished that completely. So there's some talk whether at that time whether fees would be brought back in, and it might be kind of more cost effective. But as it stands at the moment, the fees have been abolished. So that's kind of where we're at with things just now. What we've kind of seen with our clients over the kind of last few years is that some clients do adopt a kind of more risky approach to certain things anyway. There's circumstances where they might do that. A larger employer might kind of be a bit more kind of open to risk, where a small business might not be. And certainly some of the charities and kind of family businesses we work with are a bit more kind of cautious. But what it will probably mean now is that because that lodging fee has been abolished, some of our clients and some businesses who may have been a bit more open to risk might just need to be a bit more kind of cautious around that, because obviously at the back of your mind now is that you're thinking, well, yeah, if I make this, if I go ahead and make, this person, unemployed because of you say it might be misconduct, and you're not quite sure if it constitutes gross misconduct or not. You might have kind of thought in the past, well, I'll take my chances at tribunal. The chances are they might not raise a claim. That has now been, removed, so there'll be nothing to stop that individual raising a claim, because obviously if they've got the service, then that's certainly something that they can do. So what I kind of want to talk about today is just what does it mean for you as an employer. So there's quite a lot of kind of scare stories out there. I've read quite a few kind of blogs from other HR consultants, employment lawyers, and quite a lot of kind of scare stories out there that that's going to impact on employers. Yeah, I guess it will. However, from my point of view, is if you've got good procedures in place, you're a good employer, you treat your staff well, and you're pretty good in terms of how you treat people fairly and consistently, then I don't think you're going to have a lot to kind of worry about. However, there's a lot of things going on at the moment with economic climate, with Brexit and various other things. So, if you are a business who are kind of planning redundancies, for example, then it's going to be more important than ever to make sure that you've kind of followed a genuine consultation process and carried out meaningful consultation. So again, I understand that you might be a bit impatient. If you've only got maybe 3 or 4 people that you're looking to kind of make redundant, there's no legal obligation to consult for 30 days. What you need to do is carry out genuine consultation. But for me, that doesn't mean that you can do it within a week. So and I get that your business might be fast moving. We've got clients who are extremely impatient, and I guess some of you watching this today will be exactly the same. However, it's far better to invest that time up front and carry out a genuine consultation process, making sure that the appropriate letters are being issued, you've carried out the appropriate consultation meetings, the follow-up, etc. has all been done, and that will stand you in good stead, providing you've got a good paper trail and you can demonstrate that you have carried out a consultation process. That will certainly help you defend any claim at a later date. If you don't do that, then it weakens your kind of argument, and that is going to be quite difficult for you then to defend that. The same will apply if you are perhaps paying off temporary workers. That would apply to temporary workers and also any genuine redundancy situation. And again, quite often we'll help our clients with that in terms of the selection criteria, but the performance discussion part is sometimes quite subjective because a lot of small businesses don't have documented performance discussions, performance reviews and appraisals, etc. So it makes it a little bit difficult to try and say that someone is a better performer than someone else if you've not got documented evidence to kind of support that. So it doesn't have to be overly complicated, but if you're not carrying out some kind of informal performance discussions at the moment, observations, etc., then I suggest that that's something that you do. And again, if you are looking to kind of dismiss anyone on the grounds of redundancy, temporary workers, etc., if that's a criteria that you've then got, you have a paper trail to kind of support why you've made these decisions. And the other kind of dismissals to kind of think about is obviously if it's related to kind of misconduct. So that could be situations where you need to make sure you've got a disciplinary procedure. It's important that your managers are trained on the use of that procedure and that you apply that kind of process fairly and consistently. So if you have got issues around kind of misconduct, make sure you follow that fair process before dismissing. And if you're in any doubt, then absolutely get some advice on that before you kind of proceed. So that's really important. Obviously, as a result of the fees being abolished, there is going to be a kind of spike in claims, and you as an employer, you don't want to be bogged down with these types of claims. Your job is really important in terms of managing and driving your business forward, so it's far better to spend your time doing that than getting bogged down with employment tribunal claims and all the litigation that goes with it. So it's probably more important than ever just to kind of carry out a kind of refresh and an audit of your existing procedures, just to kind of make sure that you're kind of well covered and kind of well protected. As I said, if you are a business that is perhaps looking at some redundancies in the future, or due to the nature of your work, it's quite seasonal, and people kind of come and go, and you're kind of through hiring and firing quite a bit, then you might want to consider some form of employment tribunal insurance, just to kind of protect you should any of these kind of claims come about. That just gives you some kind of extra peace of mind should a claim come in at a later date. There's a number of brokers out there who could certainly help you get the right package for your business. I've put a blog article on that subject out fairly recently, so what we'll do is at the bottom of this episode I'll attach a link to that, so you can kind of do a bit more research on employment tribunal insurance. But as I said earlier, if you've got good processes in place, if you're an employer who treats people fairly and consistently, then I doubt you've got much to worry about here. However, if you do have any concerns in relation to potential employment tribunal claims, policies and procedures, and how to kind of manage staff more effectively, then please get in contact. Feel free to kind of reach out with any questions or any concerns that you may have. So thanks for watching, and we'll be in touch again next time.